Hi, everyone. Today we have Ruth Walters, staff attorney with Foster Garvey out of the Seattle office. Ruth focuses on hospitality operations and IP and technology transactions in the hospitality industry. She advises clients on matters such as group sales and event contracts, as well as various vendor and consulting relationships. She also assists with licenses, spa, and restaurant third-party management agreements, in licensing of video on demand technology, music licensing, and co-branding and marketing agreements and practices. Today, she is going to be talking to you about group sales and event contracting during and after COVID-19. Please welcome Ruth Walters.
Thank you. So another title I considered for this talk was I Dream of Force Majeure, because I have at least 3 times. But that seemed a little lighthearted for the devastation of what's happening in the industry right now. So for those of you who don't practice in this area, a quick framework for what I mean by global sales or group sales and event contracting. It can be anything from a small wedding of 25 people up to a full buyout of the hotel and all function space and lots of anticipated revenue and banquets and spa appointments galore. So to be honest, I am a little biased. I'm mostly a hotel lawyer, although I do have some group clients. So much of this talk will be from the perspective of my poor, devastated hotel clients. So a couple things that make this type of contracting during a pandemic or a major force majeure event of any kind challenging is a couple things. First, the business is often booked very far in advance, a year, 2, sometimes 3 for the larger scale events. So there's always a tension in this type of contract between a hotel that wants certainty, business on the books, and a group that understands that in a couple years, maybe people won't want to go to the event anymore, financial situation, and of course, here we are in a pandemic. And they want flexibility, easier get out of jail free cards, that sort of thing. So that's one particular challenge with this type of an agreement right now. The second is the concept of delay or suspension in performance during a force majeure event that might make sense for a software license or some kind of operating agreement, equipment delivery, that sort of thing, just doesn't really make sense here. So what we're talking about in these situations is a complete termination of the agreement, cancellation of the event, nothing happens, hotel loses revenue, group is trying to get its deposits back. So it's been a challenging several months, as it has for many people. So with that in mind, I went back to law school these last few months, and I have parsed the words illegal and impossible in force majeure clauses until I can't see straight. And one of the main concerns that we have on the hotel side certainly is the timing of the request. So I ask myself, and my clients ask me, does a pandemic in March, for example, mean that performance in October or November or December or even January of the following year will be impossible? What is the effect of a state of emergency or a declaration of a global pandemic on a party's ability to have an event? Sometimes it has a lot of an effect, the stay home, stay safe orders, for example. But simply a declaration of a state of emergency can be just an administrative procedure that sounds scary, but actually doesn't affect whether the parties can or cannot hold an event. So I ask myself also the philosophical question, is anything impossible? And we're lawyers, we know that, of course, not. You can always argue one way or another. So within this context of everyone really legitimately panicking, both the groups who don't want to send their people out and my clients who want to hold on to the business, it becomes important to have a brand-wide approach on the hotel side. So to come up with some kind of procedure and a set of strategies for responding to what are an ocean, a tsunami of force majeure requests. How far out will you permit force majeure termination? Are there any distinctions to be made between a lot of revenue and a little bit of revenue? Actual human beings, say weddings versus sophisticated companies, and to have something like that in place to smooth or try to smooth a very difficult process. So next slide, please. Another thing I've learned during this period is both that having a clearly worded, non-ambiguous contract is important, which I'm glad to hear that because I'm a contract lawyer, but also at a certain point, once things fall apart, lawyers of my type anyway can become largely irrelevant. My role has been and is to help guide negotiations. We all want to compromise. And my clients in particular, various hotel businesses are scrambling to get business back on the books, even though in some cases, as the pandemic continued, the hotels themselves were closed. So the first and best option is to rebook the event, to negotiate moving the event, maybe apply existing deposits and damages to the rebooked event, anything listed on this slide, because of course, once negotiations are open, and particularly during the pandemic, groups will take every opportunity to renegotiate some terms to make them more favorable. Totally understandable, and we're all rolling with it, but I have gone from interpreting force majeure clauses now to negotiating them over and over. And one particular situation that has occurred that I've not seen particularly recently is the concept of what constitutes impossibility for a group's performance. Mostly the group just has to pay. So what does that mean? What does it mean if they say, well, 75% of my attendees can't come? Is my performance impossible? Well, I could pay you, but of course I don't want to, and I'm not receiving anything. So again, my clients take the lead, the business people take the lead, and I follow papering over everything as a lawyer should always do. Next slide. And here we are, you can read the slide, in the present day. More force majeure, addition of terms that make people feel secure, like pandemic, outbreak, epidemic, softening the standard by which a force majeure termination will be permitted, unhealthy. Hotel lawyer, no. Group lawyer, yes. Some things I have seen that I have never seen before is a group attempting to have its own internal travel policies constitute a force majeure event. So if Google, for example, and this is not an actual transaction, I just thought of Google, has implemented a policy where there is no corporate travel whatsoever unless absolutely necessary, does that constitute a force majeure event for a hotel? Because of course it's within the control of the group to decide not to travel. However, the reasons for not traveling are outside of their control. We are seeing, of course, many specific COVID-19 related clauses, more aggressive concern with health and safety laws, compliance with CDC deadlines, and a whole host of additional termination rights. And in particular, groups are wanting to build even more flexibility into these agreements by giving themselves the right to renegotiate or unilaterally amend the agreement if the situation worsens or doesn't improve. So, next slide. And here we are in the present day, and of course, all of this past is still with us. And moving on, the primary issue is that COVID-19 is now a known quantity. So is it really a force majeure event? If you are contracting for an event in now 2021, 2022, in the middle of a pandemic, does that mean that you can never terminate for force majeure because of COVID-19? And so the theme of these negotiations is to try to allocate the risk throughout the terms of the agreement to decide what happens if COVID doesn't get better, if it worsens, if there's another horrific pandemic, who bears the risk, and making that part of the negotiations underlying many, many changes that groups and hotels both want to make. Again, there's always a benefit to being the party holding on to the money. That's even more true today than it was a year ago. We've had some very, very serious negotiations about indemnity language. Does a hotel need to indemnify a group if someone gets sick? And then some very brief considerations of attendee waivers. So Things are still very much up in the air. My practice is still largely consisting of discussing force majeure and what constitutes force majeure events. And so what I've learned primarily throughout this process is whatever can be done in a contract to force the parties back to the negotiating table should be done. Business relationships often guide these types of arrangements. We know that the parties are going to negotiate in good faith to work things out. But now a large part of the practice is making sure that that happens as opposed to just a cancellation and total loss of the relationship. So that's it. That's all I have time for. I hope that you decide to talk to me in greater depth later. Thanks.
Thank you so much, Ruth. That was fantastic. We are so glad you'll be joining us for a deeper dive roundtable. If you are an attendee watching this right now, we will post the agenda and you'll be able to find out exactly when Ruth will be hosting her roundtable and join her then. Thank you again, Ruth, and we will talk to you soon.
Okay.